Hello, everyone. This is Aaron Gelb, and just wanted to welcome everybody. Thank you for joining us for our 8th installment in Conn Carey's 2021 OSHA webinar series, OSHA's respiratory protection rules, the top 5 reasons to get it right, and the 5 most common or frequent employer mistakes. If you're a regular attendee that's used to our 1 webinar per month format, you may be wondering, how are we already at 8 webinars when we're only into the 5th month in 2021? And the answer to that is that with COVID and all the work and challenges that has posed to workplace safety professionals, that we've added several bonus webinars. Hopefully you've been able to avail yourselves of those as well, as part of our efforts to keep our friends and clients fully briefed on everything that's going on in the world of workplace safety and health. If you are a webinar regular, you also know that we particularly enjoy presenting these top 5 programs, focusing on the frequent mistakes that employers make, as well as the reasons why compliance matters with respect to certain key OSHA standards. We've covered, I think last year we did the PPE standard. Prior years we covered electrical safety standard, and one of my personal favorites, although maybe not everyone else, the Lotto standard in prior years as well. And we've long wanted to cover respiratory protection, and thought there's no better year than this one to dive into 1910-134 while in the midst of a pandemic that spreads primarily through airborne transmission. As most, if not all of you know, respiratory protection requirements exist in general industry in 29 CFR 1910, as well as in maritime, which is under 1915, 1917, and 1918, as well as within the construction industry standards at 29 CFR 1926. State plans are required to also have standards, of course, and enforcement programs that are at least as effective as OSHA's respiratory protection standard, and may, of course, have different or more stringent requirements as certain states do. In addition to the various industry standards, we'll be digging into how certain standards impose additional requirements related to the protection of employees from airborne contaminants, and I think Amanda's going to be talking about some of those. So with that, let's begin with some brief introductions. My name is Aaron Gelb. I'm based in Chicago, where I lead the firm's Midwest OSHA practice, although I do handle matters, workplace safety and health matters across the country. Do obviously a lot of my work in Illinois with the 5 area offices here in the surrounding states, both federal states like Wisconsin, Missouri, as well as state plans such as Michigan and Iowa and Indiana. I've been in Chicago for the past 22 years in private practice as a management side lawyer for more than 25 years. Attended the University of Chicago undergrad and law school at the University of Texas, go Horns. And I am excited to be joined today by 3 of my colleagues, Amanda Walker, Vita Lashkari, and Ashley Mitchell. So I'll ask them to introduce themselves now before we dive into the content.
Hi, my name is Amanda Walker, and I am joining from Atlanta, Georgia, and I'm a partner in the OSHA practice. I am probably one of the few attorneys out there who is exclusively practiced OSHA law since graduating from law school. I started in the solicitor's office and the front office of OSHA, Department of Labor in Washington, D.C., and have been out helping clients navigate OSHA issues, whether it be compliance, enforcement issues, as well as trade associations advocating for issues related to occupational safety and health. Also get involved sometimes with other agencies, but it's usually closely related to OSHA, whether it's EPA and the RMP or DOJ, when there is some sort of criminal element or some sort of consideration along those lines. I'll turn it over to my next colleague.
Hi, all. My name is Vita Lashkari. I am an associate at Conn Carey and a former attorney investigator of the U.S. Chemical Safety Board. I represent employers in the full range of matters regarding the OSHA Act and handle the full range of litigation related to contesting OSHA citations. I also manage inspections and investigations by OSHA, the CSB, EPA, and other federal, state, and local agencies. It's a pleasure to be here with you today, and I will turn it to my colleague Ashley to introduce herself.
Thanks, Vita. Hi, everyone. My name is Ashley Mitchell, and I am based in the Chicago office. I am an associate here at ConMoss Carey, practicing in both the labor and employment and workplace safety practice groups. I also represent employers in a full range of matters under the OSHA Act, and I do have quite a bit of experience now representing employers in inspections, especially as they relate to COVID-19, which we will discuss later in the presentation.
Thanks, Ashley, and it's been a pleasure adding Ashley to our team here in Chicago. One of these days we'll actually work together in the same office, although we're in the same city. So, and obviously we have the pandemic to thank for that. So, and that is obviously one of the topics that we will be folding into our discussion of the respiratory protection standard. So I'm going to begin by going over 5 reasons why employers should prioritize compliance with the respiratory protection standard. Obviously, there are many more. What we've tried to do for you all in preparing for this program and developing the materials is basically take our collective experience dealing with this standard and rather than just kind of downloading statistics and saying what are the 5 most frequently cited sections of the standard, which obviously informs our analysis. But what we've done is what are the reasons from our perspective that it is important to get this right, and then what are the mistakes that employers are making, which is Amanda will cover that portion. But and again, it's not just the mistakes based on the frequency of citations, but just things that we see in the course of inspections, things that are pointed out by compliance officers, and kind of the things that I guess if we were running a program that we would try to either prioritize or focus on. Then Bita and Ashley will dive into respiratory protections issues that are implicated by COVID, share some experiences that they've had dealing with OSHA as they inspect and focus on respiratory protection, particularly in healthcare. And then we'll end with talking about some practical steps and considerations, things that you all can do to try to mitigate the hazards and risk for citations going forward. So I'll begin, as I said, with the 5 reasons to prioritize compliance with the standard. It's important, I think, to understand the context of the respiratory protection standard. 1910-134 falls within subpart I, which is the personal protective section of the OSHA standards. So this includes all manner of personal protective equipment, or PPE, from hand and foot protection, head, face, eye protection, as well as electrical protective equipment and fall protection. And because respirators are PPE, that means that you need to consider their use and your reliance on them in the context of the hierarchy of controls, which prioritizes the use of hazard elimination, engineering controls, and administrative controls. So this isn't, and I assume most of you all that work within this standard already know this, but for those of you that are newer to respiratory protection, in part because of the pandemic, and if you've gone through hazard assessments with respect to COVID, you know that OSHA, whatever the hazard is, whether it's an airborne contaminant or something else, the first question is, can you eliminate the hazard? Can you do something that substitutes the task so you're not exposed to the hazard? Not, then you look at engineering controls. And so respirators are required when effective engineering controls are either not feasible or while they're being instituted. So again, you're probably used to going through this assessment process in COVID with respect to how do we change the workplace? How do we protect people? It's the same analysis with respect to respiratory protection outside of the pandemic, which is whatever that contaminant is in your workplace, are there ways, engineering controls that you can put in place so people don't need respirators? If not, and you have to go through that feasibility analysis and have information or documentation to be able to back that up. So in other words, you should not simply default to the use of respirators and need to first consider other methods of controlling for these contaminants. Nonetheless, and I think perhaps the most important reason why you need to get respiratory protection right is that respirators save lives. And as you can see from the graph on this slide, that there are a significant number of fatalities every year due to a single inhalation episode. And that's not, obviously, we're not including airborne contaminants that create or cause diseases or illnesses kind of over a prolonged exposure, but simply from a single episode of inhalation can lead to a fatality. So those numbers range from the 30s all the way up to close to 60 employees per year. So I think almost anytime we talk about the reasons that compliance with a particular standard is important, putting aside fines and citations, it's protecting the lives and health of your employees first and foremost. Secondly, kind of getting back to the compliance aspect, however, the respiratory protection standard 134 last year was the third most cited standard, and it probably does not come as a great surprise to those of you, which I think is everybody that's been dealing with COVID-19. It historically has been in the top 5, but it's moved up in the rankings, I think due in large part to all the citations that were issued to primarily to healthcare providers, both hospitals and long-term treatment centers and nursing homes over the past year. So it's really, as far as general industry now, right, essentially the second most commonly cited standard, since when you look at fall protection, so much of that falls within the construction standards. So protecting employees, avoiding citations, two of the, I think, obvious and very clear reasons why compliance with the standard is so important. This is a slide I think you've probably seen quite a number of times if you've participated in our webinars. It's one I think just that bears repeating again here briefly. Another reason why you want to comply with the standard anytime you're dealing with a standard that's in the top 10 or the top 5 most frequently cited standards. That means that there's a high risk of repeat, particularly during, again, not to belabor the point, but during this pandemic that is likely not only not going away in the immediate near future, but with the expected issuance of a COVID-19 standard, the COVID-19 National Emphasis Program, we're going to see a continued focus on respiratory protection throughout the rest of this year and presumably into 2022 as well. I think Ashley and I just had a conversation with a compliance officer in a state that before the citations was even issued, who had found some issues or concerns with this employer's program, was saying, you're going to be at risk of a repeat. So we haven't even been cited, and we're already warned about the risk of a repeat. So when you're dealing with the second or third most frequently cited standard, you're going to be at risk in a repeat. And as those penalties keep increasing each year, with a potential repeat, and if OSHA were to go focus, as I've seen in some of the cases where they feel their concerns with employers' compliance are particularly problematic, rather than grouping those citations under one violation of the respiratory protection standard, they could opt to go with repeats for various sub requirements within the standard, whether it's fit testing, whether it's medical evaluations, et cetera, and issue multiple repeats and quickly get to $300,000, $400,000, $500,000. Obviously a worst case scenario, but something that we feel compelled to mention and you emphasize as another reason to focus on compliance with this standard. Fourth reason, and again, this kind of dovetails with the comments that I've just been making about COVID-19. We are expecting a standard any day now to be issued, an emergency temporary standard. I think as most, if not all of you already know as well, OSHA has already released and has begun inspections as part of its COVID-19 National Emphasis Program. And within that National Emphasis Program, obviously there will be a continued focus on respiratory protection in various industries. So, what does that mean? Again, it means that this is something that OSHA is going to be looking at when they come into your workplace to conduct these inspections. But this concept of a programmed inspection, obviously, which again means inspections that are done without a complaint, without an incident, without a reported fatality or hospitalization, that the agency can and will simply show up at your door because your NAICS code falls within the list of covered industries. But it's not limited alone to COVID-19. So the fifth and final reason that I will mention as to why compliance with the standard is so important is outside of COVID, you have a number of national emphasis programs that implicate respiratory protection. If you work with, your employees work with or exposed to respirable silica, hexavalent chromium, or lead, each of the, if you go into the program documents for those national emphasis programs, you see that one of the things that the compliance officers are expected to evaluate and dig into is your respiratory protection program. So again, not only do you need to maintain that program because it keeps employees safe, but it's going to be you have a greater chance of having that program scrutinized, evaluated, and picked over by OSHA simply by virtue of the industry or in your operations fall within these national emphasis programs. So taken together, those are the 5 reasons that we really do recommend focusing on compliance with the standard. And I will turn it over now to Amanda, who will talk about the 5 of the common mistakes that we've seen in this area.
Excellent. Thank you, Aaron. Yes, digging into the 5 common mistakes that we see. The first one on the list is voluntary use. And this has come up over and over and over since the COVID epidemic started, or pandemic started. It is so important for employees to get the language right when talking to OSHA, whether or not a respirator, and the primary type that we're talking about for voluntary use is going to be your half-face filtering face piece. People might know it as an N95. That is covered under the standard. And that is something that employers can provide to employees to mitigate nuisance dust. I see it a lot, sometimes maybe for other hazards where they might not reach the Pell or be required to have a respiratory protection program, but they allow employees to wear the filtering face piece voluntarily. And so they think it's voluntary and there's not really anything they have to do with it. But that is not the case. Under OSHA's respiratory protection standard, there is a requirement. If you are going to allow employees to use a filtering face piece or an N95 in the workplace, or even provide it to them, there is an Appendix D that provides some notification to the employee about keeping the respirator in a clean condition, making sure that it's in a good working order or it fits well. And so you have to have this Appendix D information. You have to provide it to employees. And we see that missed by a lot of employers who think they're doing the right thing, trying to work with their employees and giving them voluntary dust masks to wear on the work site. And OSHA comes in and they ask to see whether or not they have this Appendix D on file, or if they've provided it to their employees. And it's always kind of an issue that trips up. One thing I think it's great if you are going to provide voluntary respirators to employees is to have it as part of your initial training so that you just get it documented and on file up front. It's not something that you have to use or do on an annual basis as with some other requirements. So primarily see the voluntary use aspect with regards to N95. But it can also pertain to higher level respirators as well. Going to the next slide. If it does, for some reason, going back one. Sorry about that. It can also pertain to, there might be a reason somebody shows up with a respirator, which is a plastic or elastometric respirator that's kind of a little bit more plastic. It might have canisters or some other filters on the side, and they bring it from home and they decide they want to use it in the workplace. Well, in that case, even if it's voluntary, you're going to have to do some more work to come in compliance with OSHA's respiratory protection standard. At first, you need to at least have kind of the basics of a written respiratory protection program. So you have to have more than just that it's signed Appendix D. You have to have some more documentation and more elements of the written respiratory protection program. And then secondly, you have to confirm that that employee is medically able to wear that respirator. You're not going to cause, or that employee is not going to cause a greater hazard to themselves by wearing that in the workplace. So usually that is something that needs a medical evaluation, and we'll talk a little bit more in detail about that. And then we have the exception here. You don't need those two elements if you are dealing with a dust mask, such as an N95. Another common mistake we see is getting the right respirator for the right task. And OSHA outlines its assigned protection factors. It came out, I think, 2008, 2009, after the current respiratory protection standard was issued. A couple of years later, they came out with some supplemental documentation with regards to guidance on what respirators employers have to provide to employees for the different circumstances. You know, I think there's maybe 10, don't quote me on this, but there's probably about 10 different types of respirators out there. Talking about the N95, the half mask filtering face piece that has an APF assigned a protection factor of 10. And then you get up to some of the more higher level respirators, such as a full face piece self-contained breathing apparatus that has a APF of 10,000. Most of them are kind of on the lower end. You know, you would have to have something of a 10,000 factor if you were in an immediately dangerous to life and health situation. But we also see that employees don't necessarily get the right level of respiratory protection to employees for the job that they're doing. So it's important to pay attention to that if you're dealing with high-level contaminants, vapors, gases, especially things that could be immediately dangerous. One breath could result in a negative outcome, such as a fatality. So one thing, and in documenting that and providing all the details that go with that, to making sure that you have the right respirator for the task at hand. The third issue we see with regards to respiratory protection standards is that employers think if I'm complying with 1910-134, which is OSHA's general respiratory protection standard, then I'm good. I'm in compliance. Well, the majority of the time it is, but not always, especially when you are dealing with substance-specific hazards. We've pulled out asbestos as an example in this case, that sometimes those substance-specific hazards that OSHA has about 20 of in the regulatory, in their regulations on the books, is that there's a higher level of respiratory protection that is required, or additional factors, maybe some additional training or something that is added that is beyond what is in the general respiratory protection standard in 1910-134. For example, when employees are dealing with asbestos, they are not allowed to use the filtering face piece respirators for protection against asbestos fibers. They would have to use a higher level of a respirator. It might be an elastometric, it might be a hood, a PAPR, something of that sort. So not getting, once again, it's kind of a continuation of not getting the right respirator to assign to the right task, employee task, but just being aware of what's in those substance-specific standards. OSHA has about 20 of those. So if you're dealing with asbestos, silica, hexavalent chromium are some of the ones that pop into my mind immediately. But there is a list on OSHA's website for those substance-specific standards. And if you're working with any of those in your workplace, you might want to take a look at that standard to make sure that you are meeting any of the extra respiratory protection provisions in there. The fourth common mistake we see is medical evaluation. So we've talked about voluntary use, but the moment you go from voluntary use and go into required use of respirators or any sort of voluntary use respirator above the N95, you are required to provide your employees with a medical evaluation to ensure that they can wear the respirator and are not creating a greater hazard. This is a very commonly cited standard, and it was more so this year than in previous years because of COVID. We saw a lot of, especially nursing home care facilities where they did not have respiratory protection programs in place, that were all of a sudden required and requiring their staff to wear N95s and filtering face pieces. And when things started last spring, it was kind of all hands on deck and getting everybody medically evaluated to confirm that they could wear a respirator didn't always happen. So we're seeing a lot of citations with regards to that. Medical evaluations, it's kind of interesting. OSHA, when they promulgated this rule, you know, I think we think of going to a doctor's office and sitting down with the doctor. This process is somewhat evolved. It's now something that you can do remotely with your employees. You set up an account. I think there's several vendors out there. They fill out the mandatory questionnaire that OSHA has published and uses as can be found in the appendix of their regulatory standard 1910-134. And you must fill out that questionnaire. The questions are specific, cannot modify it, and have a licensed healthcare professional or someone else review that to see if there would be any concerns with regards to wearing a respirator. It asks questions about weight, you know, any potential breathing issues in the past, lungs. So it just kind of goes over and it's a high level review to make sure that there's no hidden factors that could create a greater hazard when putting an employee in a respirator. So that was a big issue that we've seen this year. Not either doing the medical evaluations, not using the appendix that is in the respiratory standard, and then also not having the documentation to show that they were completed. You don't necessarily have to have the completed questionnaire, but you have to have something signed off by a physician or a licensed healthcare professional indicating that the employee did complete or pass the medical evaluation for respiratory use. This is a one-time requirement unless, of course, the employee has a significant change in their health, maybe a substantial weight gain or loss, something that could impact the ability of the respirator to fit properly, or the use of it could impact their health when wearing it. So that's a big issue that we saw quite a bit of in 2020. The last one is also a issue that we saw quite a bit in 2020 with regards to respirators fit testing. OSHA requires that employers fit test respirators, or employees fit test respirators to make sure that they're effective. That you got a tight seal, it fits the shape of their face, and they require employers to do that on an annual basis. And this is most often, there's several different types of respirators that need to be fit tested, but the one that we saw most frequently at issue in 2020 was your N95s, your possibly elastometrics with the canisters on them. And the fit testing needs to be done with the respirator that the employee is then required to use in the workplace, or the one that they are using if it's a voluntary situation. The supply chain disruption that occurred when everybody was trying to get masks this time last year really threw a huge wrench into this issue, because we weren't able to get the respirators employees were fit tested on. So it was really very challenging. One thing that OSHA did look for on the fit testing verification forms is, you know, the model and the make of the respirator. They were trying to confirm that that was the same model and make that the employee was wearing at work. So that was a little challenging. There's two primary ways of doing the fit testing. One is the qualitative and the other is the quantitative. The qualitative is the one that we saw the most experience, or saw most frequently last year, and It was also really challenging to get the materials that you needed to conduct the fit testing. A lot of employers that we work with use a substance called Vitrix, and it was in short supply last year. I think there's only 2 manufacturers that make it in the United States, and people and employers were working on making home DIY alternatives because they couldn't get their hands on it. It's a pass or fail test, and it assesses the adequacy of the respirator fit and relies on the individual's responses to the test agent. So it's a bitter tasting substance. There's also some other ones that involve smell and determining whether or not the Vitrix can make its way through the mask to determine if it's a proper fit for the employee. The other one, the quantitative, has to do with an assessment of the adequacy of the respirator by measuring the amount of leakage into the respirator. So it's more of a numerical measuring method that's used. But OSHA does recognize both options. It's important to note that fit testing is an annual requirement. So just because you do it once, you need to continue to do it if you're requiring your employees to wear respirators. And really important to get the documentation. There are certain elements that need to be on the fit testing record, the employee that was tested, the model that they were tested on, the date, and those other items. Really important to get there on the fit testing documentation. So those are the most common issues that we saw with regards to respiratory protection in the last year. Certainly a couple of those were brought to the forefront due to COVID and the COVID response, but they've always been around and just not as frequent as they were this past year. Now turning it over to my colleagues for the next segment.
Great. Thanks so much, Amanda. Okay, now getting into COVID-19. So obviously, because of the respiratory nature of the virus, there was a lot of discussion around how to protect workers, especially those in healthcare, as Aaron mentioned, from COVID-19, including through the use of PPE like respirators. So let's start at the beginning, about a year ago in 2020. So in 2020, OSHA declined to adopt a COVID-19 Emergency Temporary Standard, or ETS, which is a world away from where we are now, and which Ashley will get into in a bit. But in large part, OSHA said it did not need an ETS because its existing standards, including its respiratory protection standard, provided adequate protection to workers. It also, in addition to the respiratory protection standard, it also pointed out to its PPE standards as well as the general duty clause. And on the enforcement side of things, we saw OSHA really focus in on high-risk industries, particularly healthcare. One of OSHA's first guidance documents on COVID-19, which came out in March of last year, established this occupational risk pyramid for COVID-19, which breaks down risk into 4 categories: very high, high, medium, and lower. And very high exposure risk jobs were defined as those with high potential for exposure to known or suspected sources of COVID-19 during specific medical, postmortem, or lab procedures. And the examples given included healthcare workers, specifically those performing aerosol generating procedures. So OSHA really focused there, those very high risk level, and I'd say also on the high risk workplaces as well, and really prioritized COVID-19 fatality cases. And the reason this is important is because you'll see in a couple slides, a lot of the citations that came out of these inspections involved the respiratory protection standard. And just, with respect to, all other kind of COVID-19 hazards, for the most part, those were addressed by notices of alleged hazard or rapid response in investigation requests. And here you'll see just on the bottom of the slide, a quick summary of the COVID-19 enforcement data up to January 20th, 2021. When President Biden took office, you'll see there were about 12,000 or 13, almost 13,000 closed federal cases and about 35,000 closed state cases. And just a quick last point on the different risk levels I mentioned earlier. Just a quick heads up that those are definitely still out there. For example, Virginia's COVID-19 standard includes this concept of different exposure levels. And we also think that the upcoming federal ETS might as well. And the reason being, at least in part, is that the Department of Labor, they issued a public announcement a couple of weeks ago that they had set standards, plural, to the Office of Management and Budget's Office of Information and Regulatory Affairs, or more commonly known as OIRA. So we think that use of the word standards, plural, might indicate one standard for higher risk industries, such as healthcare, workplaces, and another standard for all other industries. So just going to the next slide. Okay, so now moving on to enforcement guidance from OSHA in 2020, which is where we did see a lot of movement, I'd say, from OSHA. So remember, one thing I think a lot of our clients or employers in general get confused about with these enforcement memos is that they're not exceptions, they're not exemptions, they're not waivers. They're really, OSHA's way of telling their compliance officers how they should apply enforcement discretion before issuing citations. So, that's just a point of clarification. And so here on the bottom of the slide, you'll see a full list of COVID-19 enforcement memos. And what you can see right away is that most of the memos are related to respiratory protection. And we won't go through each of these individually, but just highlight some of the major themes that came out of these. So one of the first enforcement memos OSHA put out, and this was on March 14, 2020, was this memo about annual fit testing requirements. So as Amanda just said, that is a requirement of the standard, is that fit testing be done annually. In this memo, OSHA explained its recommendation that healthcare employers follow CDC guidelines, including taking measures to conserve supplies of respirators while safeguarding healthcare providers. OSHA said it would exercise enforcement discretion concerning the annual fit testing requirement, which is at 1910-134F2, as long as employers met certain enumerated conditions. And one of those conditions is performing initial fit tests with the same model, style, and size respirator that the worker will be required to wear for protection against COVID-19. And OSHA included language, initial fit testing is essential to determine if the respirator properly fits the worker and is capable of providing the expected level of protection. So this enforcement memo was really directed at annual fit testing, not initial fit testing. And I think there was a lot of confusion there. A lot of employers were kind of implementing respiratory protection programs for the first time. And it was really difficult to sort of get, as Amanda said, just the fit testing supplies, which I'll get into more in more detail later. But I think there was there was this memo about annual fit testing, but it really did not extend to initial fit testing. And then by early April, OSHA developed enforcement memos, which really addressed the shortage of respirators. I think any employer can attest to the fact that finding respirators during this time was nearly impossible. So OSHA came up with this guidance on how to deal with the supply shortages. In particular, in one of the memos, OSHA said all employers should make a good faith effort to provide and ensure workers use the most appropriate respiratory protection available for the hazards against which workers need to be protected, and sort of gave this top-down approach on how to do that. OSHA said all employers should, one, implement the hierarchy of controls, which Aaron alluded to earlier. That's, using engineering controls first, administrative controls, PP on the bottom. To prioritize efforts to acquire and use equipment in the following order, and then it listed out sort of at first, on top is, NIOSH certified equipment, which of course was in almost no supply, I'd say, around this time period. And then on the bottom, in between there was equipment certified in accordance with standards of other countries. And then at the bottom, of course, face masks. OSHA also said employers should prioritize efforts to acquire and use equipment that has its manufacturer's recommended shelf life. Fourth, prioritize efforts to use equipment that has not exceeded its intended surface life. And then 5, use homemade masks or improvised mouth and nose covers as a last resort. as a last resort. Another piece of guidance on the next slide you'll see is this April 8th memo, which is really aimed at the supply of fit testing kits, which is important because, I think we're all well aware of the shortages of masks that occurred last year. But as Amanda mentioned, there was also a very short supply of fit testing kits, which, again, employers do not necessarily need to conduct annual fit testing, per OSHA's earlier enforcement memo. They still had to conduct that initial fit testing. So these kits were, in very high demand, and the resources became depleted very quickly. OSHA's enforcement memo on this point informed that in the absence of quantitative or qualitative fit testing capabilities, most respirator manufacturers produce multiple models that use the same basic head form for size and fit, and that manufacturers may have a crosswalk, which is a list of their respirators with equivalent fit. And then OSHA suggested that if a user's respirator model is out of stock, employers should consult the manufacturer to see if it recommends a different model that fits similarly to the model used previously by employees. And then it directed OSHA field offices to, exercise enforcement discretion, regarding compliance when an employer switches to an equivalent fit. So that's the guidance. And practically, I'm not sure how much this helped though, because of the supply shortage of even, those equivalent fitting masks. We have clients who are in touch with suppliers and manufacturers on a constant basis. I'd say, probably weekly, if not daily. And the availability of both just on the side of, with respect to masks, but also with respect to fit testing kits was really almost non-existent. And just to round it out, more recently, OSHA also issued enforcement guidance regarding decontamination of filtering face piece respirators and tight-fitting powered air purifying respirators or PAPRs. Okay, let's now get into enforcement details. So this is just the first sheet of results that pop up when looking at OSHA's COVID-19 enforcement data. And in looking at this, two things really stand out to me. First is you'll see that many of the establishments are in healthcare. You've got rehab centers, medical centers, healthcare groups. SNF stands for SNF. It's a skilled nursing facility. So that really goes back to what we discussed earlier. OSHA really focused in on healthcare and very high or high risk exposure level category employers. And the other thing you'll notice right away is a lot of respiratory protection standard related citations. All of those 1910 134s you see there, those are your respiratory protection standard citations. So 134E1 is the medical evaluations that Amanda spoke about. F2 relates to fit testing. And those were the two major buckets, I'd say, medical evaluations and fit testing. We also saw citations for C1, which is for the respiratory protection program, and K1 for training. And just on the fit testing piece, at least from what we've experienced is that a lot of employers have had a particularly hard time taking those fit testing citations because going back to what we were just talking about, they were extremely hard. It was extremely hard to find any masks or fit testing supplies. And as Amanda talked about, the other part of that is there was a complete hodgepodge of what employers could get. And frankly, I'd say employers felt lucky to get anything. I mean, a lot of the masks came from donations, made to local offices of emergency management. We've had clients just tell us over and over again that we just felt really, really lucky to get our hands on any respirators or masks. So there was never this sort of steady stream of one type of make or model, and no one really was in the position to be choosy. So even if we did have fit testing kits, given the fact that we had so many different makes and models on a constant basis, that initial fit testing on one make or model would be sort of obsolete by the time the next round of masks came in. So, ideally, of course, yeah, we would do that initial fit testing. But I think that's just not really how things played out, and just something to keep in mind as well. So just on this last slide, it just kind of sums up what we've already discussed. You'll see at the top here, the three most cited standards related to COVID-19 inspections are respiratory protection standard related. And again, like we just mentioned, the two big buckets are fit testing and medical evaluations. You'll see fourth and fifth from the top are reporting and recording related. And we definitely got a good share of those as well, but that will be for another time. Again, we can't downplay how much of a role, the respiratory protection standard has in this world of COVID-19, and we certainly expect it will continue to play a role through OSHA under President Biden's term. So with that, I will hand it over to Ashley to speak to COVID-19 and what we've seen so far with this new administration and what to expect next.
Thanks, Bita. So as Bita said, OSHA today is in a completely different place than it was last year. Starting around Friday, January 29th, OSHA issued a detailed set of new COVID-19 guidance for employers and workers, which was entitled Protecting Workers, Guidance on Mitigating and Preventing the Spread of COVID-19 in the Workplace. Now, it's important to note that this is only guidance, and so the document technically does not create new legal obligations, but OSHA under the Biden administration has already made clear that COVID-19 enforcement will be a priority, and we've seen that with this work through of the emergency temporary standard. And this guidance will almost certainly be relevant to the COVID enforcement efforts until we see that ETF. OSHA's new guidance does reference previous guidance issued by OSHA, the CDC, and the EPA over the last year, but it does have a different and more mandatory tone and includes a few important substantive differences, and as for how it may be used in enforcement, regardless of a new emergency temporary standard. As to the substance of OSHA's new guidance, there's a lot of overlap and similarity from what we've seen in OSHA last year, but the notable differences is that this guidance includes a much stronger recommendation for all workplaces to develop a written COVID-19 infection control plan. It also talks about how employers should conduct COVID-19 hazard assessments, and it pushes employers to adopt policies protecting employees from punishment if they remain out of work due to potential infection. And then on the next slide, we'll see other notable guidance includes communicating with workers in a format and language that they can understand, especially for those non-English language speakers and American Sign Language. Setting up an anonymous process for workers to voice their concerns, making the COVID-19 vaccine available at no cost to all eligible employees, ensuring that those employees who do become fully vaccinated still follow the same protective measures as they did prior to receiving their vaccination. There's a clarification about the additional circumstances that could trigger a close contact quarantine requirement. So in addition to being within 6 feet of someone with COVID-19 for a total of 15 minutes over a 24-hour period, employees should be required to quarantine if they provide care at home to someone who's sick, they had a direct physical contact with a person who has COVID-19, direct physical contact meaning like a hug or a kiss. They shared eating or drinking utensils with a person who has COVID-19, or someone who has COVID-19 sneezed, coughed, or somehow got respiratory droplets on them. And also with this updated guidance, we see an incorporation of the CDC and ASHARE, which is the American Society of Heating, Refrigerating, and Air Conditioning Engineers, guidance on improving ventilation in the work environment. We can also see that the updated guidance on COVID-19 includes a section on use of PPE when necessary. And so this guidance, as you can see on the next slide, there are respirators there. And this guidance encourages employers or requires employers to use PPE when necessary. And so PPE is everything from goggles to face masks and shields. And so PPE, the respiratory protection part, is what we're focusing on today. And so it's imperative that as employers are thinking about COVID-19, returning employees to the workplace, that they are also thinking about this respiratory protection standard, which has been noted by my colleagues is one of the more frequently cited standards during COVID inspections. And so on the next slide, we see here just some key takeaways here. As employers are thinking about how to implement and follow that January guidance, it's imperative that the PPE is provided in accordance with all relevant OSHA standards and other industry-specific guidance. Specifically, the respirators, if necessary, must be provided and used in compliance with 1910, 134, and I believe Amanda will be talking about this in a second here, but that includes making sure that the medical determination has been made, that the respirator is required, that there is fit testing, and that there is training on the correct use of the respirator itself. And as if the Biden administration has not done enough for us, we have the COVID-19 National Emphasis Program. And so the goal of this NEP is to significantly reduce or eliminate worker exposure to the COVID-19 by targeting industries and work sites where employees have a high frequency of close contact exposures, and therefore controlling the health hazards associated with such exposures. And so this NEP was effective immediately, and so it was issued on March 12th and it took effect on March 12th, and this is despite the typical 90-day outreach period that precedes inspections under a new NEP. And OSHA did this reasoning that OSHA has continually, quote, conducted outreach at the national, regional, and area office levels throughout the duration of the pandemic outbreak. Thus, the 90-day outreach threshold has been met, and area offices may begin to initiate inspections under this NEP on the effective date. And so this COVID-19 NEP is scheduled to remain into effect for up to 1 year, although OSHA does have the flexibility to amend or cancel the program as the pandemic subsides. And so the three targeted goals for these programs the three targeted workplaces for these inspections are high-risk healthcare establishments, high-risk non-healthcare establishments, which include warehouses, storage, and retail shops such as grocery stores, and then third, non-healthcare critical infrastructure industries. And OSHA explained that inspections under the COVID-19 NEP will include some follow-up inspections of work sites previously inspected. So I know at the beginning of the presentation, Aaron mentioned, how those repeat violations can quickly add up. And so if a work site is inspected under this COVID-19 NEP and the work site does in fact receive a citation, if OSHA does decide to circle back under the same NEP, it could very quickly set the workplace up for a repeat citation. And so the last thing we wanted to cover as we think about COVID-19 in the workplace is the status of OSHA's emergency rulemaking. As you may already know, in the last week of April, OSHA delivered the proposed final rule to the White House's Office of Management and Budget, or OMB, and the rule was then characterized on OMB's website as in the final rule stage, meaning it will be either approved by OMB and immediately published in the Federal Register as a final rule, or sent back to OSHA for more work. At this point, it is our understanding that OSHA has been coordinating closely with OMB through the rule drafting process. Therefore, the expectation is that the rule will go on to the final register and it will not have to be returned to OSHA for more work. And so as we look to the timeline of the ETS, as of this morning, there were stakeholder meetings with OIRA scheduled through next Tuesday, May 18th. with a total of nearly 40 meetings held or scheduled to be held in the next week. And at this time, it appears OIRA is still accepting new requests for more stakeholder meetings. But unless OIRA schedules additional stakeholder meetings, the anticipation is that the final ETS will be published sometime after those final stakeholder meetings, May 18th. And so our best guesses on the publication date of the ETS set aside, OMB technically does have 90 days to review and approve the rule or return it to OSHA for more work, but that timeline is non-binding, and in practice, the OMB review process can take less than a week or several months. But again, since this is an emergency rule and we understand OSHA has been coordinating with OMB throughout the drafting process, we anticipate OMB will move quickly. And now we will talk about steps that employers can take to mitigate respiratory protection hazards.
Hi, this is Amanda Walker, and just talking about steps that employers can take, things that you can be proactive about to prevent having any respiratory protection issues or violations. The first one is if you're required, so basically a written program is going to be needed if you have or requiring any type of respirator in the workplace, actually requiring that an employee wear a respirator, even if it is a dust mask or half face piece filtering mask. If you are required to have one, you have to have a written program that has certain elements that OSHA requires certain elements in it. There's a couple good examples. I think OSHA actually puts out an example program that you can use on their website. But one of the main things that I see in a lot of respiratory protection programs that I look at is doing the employee evaluation, determining who is required to wear the respirator and what type of respirator they have to wear. This can either be done by job task or by job title. And one thing that I often see is making the respiratory protection program broader than it might need to be. So covering more employees under the requirements. And as soon as you include a job title or a work task, if it's necessary to be there, then it's necessary. But I would be careful in crafting that, because anybody who performs that task or holds that job title, OSHA would expect to see a respiratory medical evaluation and fit test on record for them. So you need to have the program. There's some samples out there, but there's also some customization that needs to take place for each workplace, and you have some flexibility in doing that. Also have to have the section on the medical evaluations, which isn't so hard about putting a paragraph in a written program as the actual conducting the medical evaluations and getting them on file and keeping track of them. And then the fit testing procedures, the same thing. Not so hard to include it in the program, but then the actual part of doing it and keeping up with them and making sure they're up to date on an annual basis. One thing, proper use of respirators in routine and enforceable emergency situations. A lot of employers have certain respirators that they don't use on a frequent basis. They're part of an emergency supply if a immediately dangerous atmosphere was to come about. And you need to make sure that those are up to date. Somebody's in charge of making sure that those have not exceeded their expiration date, making sure that they're clean and in good working condition, should they ever need to be used. Procedures for cleaning, disinfecting, storing, and inspecting, repairing, discarding, and otherwise maintaining the respirators. This provision, I wouldn't say up until this past year, didn't really jump out at me or didn't really see very many employers struggling with this. But since we talked about the respirator shortage this past year, storage of N95. Early last year, we were seeing a reuse situation. So basically N95, if an employee was required to wear one, it was usually a limited one-time usage. They disposed of it and you moved on to the next N95 the next time you were required to wear one. Well, since they were in such short supply, there were certain measures that were put into place allowing for reuse. And the storing of those respirators between use became a tricky situation. Right now we have one issue with a healthcare employer who early on in the pandemic had provided Ziploc bags, and employees told the compliance officer, that they, were sealing them. So, and it needed to be in a breathable bag. That was what all the CDC guidance and other guidance said. So storing them is really important. Even if you're using elastometrics, there's some storing requirements and cleaning requirements that have to go along with that, as well as canisters. How frequently do you have to change out the canisters? Canisters are designed for different types of contaminants and manufacturers' recommendations on when you change it out. All things that we really hadn't seen before this past year, but became hot issues in 2020. Other things that are required to be in the program, adequate air quality. That's especially has to do with doing your forced air, whether it be a PAPR or self-contained respirator. Train employees in respiratory hazards and the proper use of respiratory protection or respirators, and then procedures to evaluate the effectiveness of the program. Asking or involving employees in the training or asking them, questions to make sure that they're retaining the information and all of that information, and posting reminders where they might go to get their respirators or where they're stored. So having a respiratory protection program with all the required elements and then following through and executing them and completing them goes a long way in meeting compliance. Moving to the next slide. Ensure proper use and maintenance of respirators. I think we talked a lot about this previously. Proper use. Certainly there's the training that goes on for respiratory protection, the respiratory protection program, and then the annual fit testing. A lot of the fit testing on the annual basis, there's a lot of reminders on maintaining the proper seal. There's a lot of good videos out with regards published by CDC. OSHA might have one as well that stresses the importance of maintaining a good seal on your face to make sure that the respirator is effective. Maintenance, cleaning and disinfecting. OSHA actually has pretty detailed guidelines with regards to cleaning respirators. So all of that, the proper storage, and making sure that you're removing dirty or defective respirators from service. Another issue that came up in 2020 due to COVID in the reuse situation. Moving on to the next slide. Train employees, making sure that you have documentation that training was provided, including as much detail in the documentation or the training materials that you can, providing reminders, including different aspects of when the respirator is necessary, the limitation and capabilities of the respirator, how to use the respirator effectively in emergency situations, and a lot of the details that you would expect to see there and are outlined in the OSHA standard with regard to respiratory protection, the training that's provided to employees. And the next slide is, I think going to Aaron Gill.
Yep. Thanks, Amanda. It's Aaron again. So just to wrap up with the two last steps that we recommend. One of which, the requirement to conduct annual program evaluations, or not annual, I apologize, periodic program evaluations. This reminds me, obviously, of the periodic inspection requirement under the lockout tagout program, but it's important. There's a number of significant distinctions. I think perhaps most important is that it's not an annual requirement such as you have with the LOTO standard. So what 134L requires is that you conduct evaluations of your workplace to ensure that your written respiratory protection program is being implemented properly. And you're also, and I think this is interesting, or interesting wrinkle, is to consult with employees to ensure that they're using the respirators properly. So in contrast to that periodic or annual inspection under the LOTO standard, you're supposed to conduct these evaluations, quote, as necessary to ensure that the provisions of your written program are being effectively implemented and that it continues to be effective. So what does that mean? You don't have the clear guidance that you have under 1910-147, which provides this time period every 12 months that you're supposed to do it. So you need to make sure that you're doing it with sufficient frequency, whether that's changes in the workplace, the adoption of new processes, new equipment, obviously something like a pandemic that comes into play. So in addition to just tracking those things, then you also are expected to regularly consult with your those employees who are required to use respirators, to assess their views on the program's effectiveness and to identify any problems. And obviously, of course, any problems that are identified during your assessment need to be corrected. So I think it's important to understand, and when you're setting out to ensure that you're developing and implementing an effective and compliant program, if OSHA conducts an inspection, and whether it's pursuant to one of the national emphasis programs I referenced, or the COVID national emphasis program, or just in response to a complaint or an incident, if they find deficiencies in your program, the compliance officer is going to will discuss your evaluation procedures with the program administrator to determine what he or she has been doing to evaluate your program. So obviously you need to make sure that your program administrator has those procedures in place and is in fact conducting those evaluations. Of course, as with any inspection, in addition to discussing it with the program administrator, the compliance officer is going to talk to your employees to find out how long these deficiencies may have existed, whether they've made any complaints about the program to the program administrator, and what, if anything, was done about it. One thing that's also, I think, particularly important here is that there is no documentation requirement associated with your program evaluations, unlike the LATO periodic inspection requirement. What that just essentially means to me is that you're not going to be cited, you're not going to get a paperwork citation. Like we see some companies are cited for not certifying. They've done the periodic inspections under the LATO standard, but they're not certifying them. There's no document, no record of it. So that's what they get cited for. So you're not going to get that type of citation here. But I think as if anyone who's gone through an inspection knows, there are many, if not most, compliance officers will take the position, if it wasn't documented, it didn't happen. And even if it did happen, what is the likelihood, just thinking practically and realistically, what is the likelihood that the program administrator is going to be able to effectively and persuasively recall and describe the efforts that he or she undertook to conduct that evaluation? If they don't have notes, if they don't have records of the steps that they've taken, who they met with, which employees did they consult as required by the standard, the odds are they're not going to do a good job when questioned by a compliance officer, recalling and describing what was done. So even though there isn't a documentation requirement, you obviously need to and should make sure that all efforts to assess and evaluate your program are documented in detail with records kept as to the various steps that are taken. With respect to the last slide, in consistent with what I just talked about, is record keeping. 134 section M of the standard requires that employers establish and retain written information regarding medical evaluations, a lot of the things that Amanda has talked about, fit testing, and the program itself. So for every employee required to a respirator, you have to establish and retain records of all medical evaluations and fit testing. Employees' medical evaluations have to be made available to the employee at their request, as well as to OSHA, obviously, in the course of an inspection. And you also, it's important to understand, though, that the standard does not intend for the employer to make medical or fit testing records available to anybody else, other than if you have a union or another designated representative as set forth in the standard. So, and as I said, these are really, and last but not least, there is the requirement to maintain a copy of the written program, make sure that it's updated, make it to the extent there are any revisions, ensure that you have the most accurate copy or the most current copy available in the event that there is an inspection. So that, I think, covers everything that we wanted to talk about. I know we're a few minutes over our aspirational goal of doing this within an hour. Just briefly remind everyone, if you don't already know, that we've created a COVID-19 task force. We have a section on our website that has a series of FAQs and a lot of other information and resources available to you. You probably already know, but don't forget to check out our blogs. They are being updated quite frequently with all the various developments across the country, both in federal and state plan states. Just another reminder that we've got another next webinar coming up in a little over a month in June, which will be looking at the big picture of the Department of Labor under the Biden administration, with more webinars to follow. I expect that there will be some flash webinars done with respect to the ETS once that issues as well. So with that, I think my colleagues and I have been trying to answer some of a number of the questions that came in over the course of the webinar. I think we've gotten to a good number of them. So if we didn't get a chance to respond to your question, we will try to reach out to you after. And if there are other questions, please feel free to reach out to any or all of us. I think our contact information should be readily available in the materials. So with that, I will conclude this webinar and thank everybody for joining us yet again, and wish you a safe and healthy rest of the week. Thank you.